So we will call the first case, People versus Shae Mullins.
Good morning, Your Honors, and may it please the Court, John Frazier on behalf of the appellant, Shae Mullins, who's present here in the courtroom this morning. I'm joined at counsel table with my co-counsel, Attorney Mick Graywall. At this time, I'd like to request to reserve 2 minutes for rebuttal. Your Honors, this case is about providing guidance and clarity to teachers, counselors, and all those who interact with children on a daily basis. This can be done by acknowledging that the Child Protection Law abrogated the common law. In so doing, the court will give guidance and comfort to mandatory reporters by confirming that the Child Protection Law means what it says, and that it is not expanded nor contracted by the common law. Your Honors, I'm asking that the court grant the appellant's application, vacate her convictions, and reverse and remand this matter for a new trial for 3 principal reasons. First, the common law doctrine of innocent agent is inapplicable in this matter, as the Child Protection Law abrogated the common law by creating a robust statutory scheme and framework of mandated statutory duties and penalties that are all contrary to long-established common law jurisprudence. Secondly, non-mandatory reporters do not have any duties or obligations under the Child Protection Law. Therefore, they do not take action that is mandated by or pursuant to the authority of the Child Protection Law for purposes of criminal exposure under MCL 722.633 sub 5. And finally, in considering the Child Protection Law as a whole and MCL 750.411A, the statutory language intentionally makes in MCL 722.633 sub 5 is limited to only those situations in which a mandatory reporter intentionally and knowingly files a false report of abuse or neglect directly to DHHS. And with that, I'd waive any uninterrupted period. Turning to the first argument, Your Honors, the Child Protection Law abrogated the common law by creating this robust statutory framework for mandatory reporting duties, obligations, and penalties. The Child Protection Law was enacted in 1975 as part of nationwide reforms aimed specifically at changing a longstanding common law principle. At common law, there was no general duty for a person to give aid or assistance to one who is in need or suffering from criminal behavior. That principle has been reaffirmed time and time again by this court, including in Williams versus Cunningham drugstores. The Child Protection Law abrogated that longstanding principle of common law by creating a framework in which those individuals who are mandatory reporters now have an affirmative obligation to take an act if they have reasonable cause to suspect child abuse or neglect. In this manner, the legislature clearly abrogated that longstanding common law principle. And in so doing, they also abrogated the entire common law field surrounding mandatory reporters. This court has recognized field abrogation in several other similar circumstances when the legislature has created a robust statutory framework. For example, in Milross, this court considered whether the Dram Shop Act abrogated the common law field with respect to negligence actions involving over-serving alcohol and resulting harm. In that case, the court correctly decided that the Dram Shop Act was an abrogation by the legislature to occupy that entire field of jurisprudence, and as such, common law doctrines such as improper supervision or general negligence would not be applicable to
Counsel,
harms
good morning. I'm going to ask a question. Help me to understand. I like to sometimes keep things as simple as possible. Where's the injustice here?
Your Honor, the injustice here is that Ms. Mullins was convicted of a felony offense for filing a false child abuse, a report of child abuse or neglect, and it's our position that that statute is inapplicable in the way that it was applied in this case, and she's now a felon, and other similarly situated persons could be charged and convicted of felony offenses improperly.
And that's the injustice here, that she My understanding of the case, and make sure I'm understanding this correctly, is that, she induced a minor to fabricate a pretty significant allegation that could be life-changing to someone, and it's a very serious situation. So I'm just trying to understand, again, using the doctrine that we're using back from common law, how is this unjust?
Your Honors, the legislature's made clear in this situation concerning the child protection law that the common law doctrine doesn't apply. The application of the common law doctrine in this case to secure a felony conviction is an injustice. And even maybe beyond the ramifications of this case, by importing the common law into the child protection law, we've created some amount of injustice, maybe just not for Ms. Mullins, but for those who are trying to adhere to and apply with the mandatory reporting obligations, because now the boundaries and standards set forth by that law are now unclear. It should not require a doctor, a teacher, a principal having to consult with an attorney to discern whether or not common law principles are going to expand their responsibilities under the mandatory reporting framework.
Counsel, you indicate that legislative enactments not only abrogate this common law rule, but they clearly abrogate this common law rule. Can you point me where the enactment does either of those? What is it in the statute that is incompatible with the common law rule or is explicitly rejecting the common law rule? What does it have to do with the common law rule?
Your Honors, Justice Markman, this particular statute, it's our position, abrogated the common law application for anything having to do with the child.
Can I interrupt you
protection
for
law.
one moment,
Sure.
please? Is that because you believe that this common law innocent agent doctrine is inapplicable to statutes?
No, Your Honor. My position and our argument is that as it pertains to the child protection law, this is a robust statutory scheme, and so application of the common law to expand or contract the scope would be inapplicable and incompatible with the legislature's intent as it pertains to the child protection law.
Wouldn't that be more likely to be true if the common law proposition in question was something that had to do substantively with what the obligations were in reporting child abuse, as opposed to a clearly cross-cutting, universally applicable common law proposition that you can't use an innocent party, say a child, to commit an offense and thus insulate yourself from the commission of that offense?
Your Honor, that position does make sense, but when you look at the child protection law itself, and if you look specifically too at other statutes that have similar crimes, specifically MCL 750.411A, where the legislature has essentially codified the doctrine of innocent agent into that statute by including the language not just intentionally makes, but intentionally causes to be made. I think if you compare those two statutes and you look at the child protection law as a whole, the legislative intent to import this doctrine of innocent agent is not found. And if the legislature wanted to expand the doctrine of innocent agent into this statute, there's no question that it could. Argument is that it didn't, and that it specifically abrogated the common law based on how comprehensive the child protection law is with regards to its mandatory reporting obligations.
Isn't it arguably that the innocent agent proposition is one of those cross-cutting common law propositions that are really grounded in logic more than anything else, that in order to be nullified by a later statutory enactment, have to exclude those propositions as opposed to affirmatively include those propositions? Aren't you putting the burden exactly opposite to where it properly rests?
Your Honor, I disagree. If the doctrine of innocent agent was so pervasive and profound, then the legislature's specific inclusion, essentially acknowledging the doctrine into MCL 750.411A, doesn't square with that long-standing cross-cutting tradition. And furthermore,
Well, there's lots of common law propositions: self-defense, the impossibility doctrine, the doctrine of transferred intent. All these tend to be applicable in many different contexts. And it's not the obligation, at least it's not generally been understood, to be the legislature's obligation to affirmatively include those doctrines within their statutory enactments, so much as to explicitly reject those doctrines if that's in fact their intention.
Sure, understood, Your Honor, but remember that we're not talking about a statute that's found in the penal code. We're talking about a statute that creates a system of mandated reporting, instructs how records are going to be kept, how records are going to be expunged, where penalties lie, and where duties lie. The inclusion and application of the common law in the context of this particular statute doesn't square with the legislative intent in terms of creating this robust statutory framework. And furthermore, as to our second argument, the statutory language of MCL 722.633 sub 5 only criminalizes behavior that's taken, quote, under this act. And so in the context of MCL 722.633 sub 5, that language must somehow limit the application of the statute, for the reason being that it is incomprehensible how somebody could take action pursuant to or under the child protection law if they are not a mandatory reporter. The Court of Appeals and the people have argued in this case that the language under this act is somehow limiting, to limit the application of the statute to only concern reports of child abuse or neglect to the Department of Health and Human Services. But at the same time, they advocate for the application of the doctrine of innocent agent.
Counsel, I'm just going to ask, you know what, because this case, I've really been thinking about this case a lot, and I'm just going to ask you a question more of a human perspective to this, because I think it's appropriate in this circumstance. Was your client, let's just say, if this plan hadn't fallen apart, in which the people that were involved in this asked the necessary questions and the child ultimately acknowledged what had happened, let's just say that hadn't happened, was it your client's plan to basically have the individual in the situation go to prison? I mean, this is like one of those scenarios that really can be terrifying to people. I mean, was that had this situation not been uncovered, was the plan to really allow for, an innocent individual to basically destroy their life, have their reputation destroyed, ultimately go to prison? I mean, was that the plan?
Your Honor, that was not the plan, and my client has denied consistently throughout these proceedings that she made any type of representation or induced her child to participate in this plan. Obviously, the jury came to a different conclusion, but the reason why we're here today is because we disagree with the legal interpretations and the evidence.
No, I understand, but I think when you do false accusations and you have a minor involved in it, that can be the worst nightmare to ever come to fruition. And that's why I'm asking that question, just from a human perspective.
Sure, understood. And the system is designed to allow it to play out. And the relief that I'm asking for here today wouldn't allow people to use children as pawns in some sort of a game. There would still be accountability available. There's other criminal statutes that are available for this type of an offense and for this type of a situation. But our position is that the statute that was relied upon by the prosecutor and the government in this case was inappropriate.
Okay, I'm good.
If you want to save your time, you have 1:23.
Sure. At this time, I'll reserve all my remaining time for
Helping you
rebuttal.
out here.
Thank you.
Morning.
Morning.
May it please the court, my name is Mark Sanford. I'm an assistant prosecutor in Berrien County. So this weekend I spent several hours jotting down some prepared remarks to give to you this morning, most of which kind of paralleled or that I'd mentioned already written in my brief. And as I stand here this morning, I see no real utility in just spitting those out to you and boring you with the same things that I've already put in the brief. So rather than do that, I'm going to go a little off script and address 2 points that I believe need some additional discussion. The first one, unfortunately, deals with a mistake that I made in my brief. It dealt with issue 1, whether or not section 5 applies to both mandatory and non-mandatory reporters. And in the first part of my response, I argue that, well, of course, the words and the grammar all point clearly to the fact that the statute was made to apply to both mandatory and non-mandatory reporters. That part of my argument, I believe, is accurate. Then I went on to address the arguments that defense counsel made in his brief and has made here, that reading that statute to include all reporters would somehow make the phrase "under this act" surplusage. In attempting to refute that, I wrote this sentence: subsection 5 punishes only those reporters who filed their reports with DHHS. And in reviewing that, that's clearly wrong. I would like to have that section deleted, if you will, or add to that subsection 5 punishes only those reporters who filed their reports with either DHHS or the police. And I believe that adds a definition, if you will, or explains what "under this act" means. It means that any report filed by anybody, mandatory or non-mandatory, with either DHHS or the police is a report that's filed under this act. Therefore, that phrase is not surplusage, It defines the mechanisms of how that report is filed and with who that it's filed. By the way, it's clear that I was wrong, that it applies both to DHHS and the police departments. If you look at section 624, it allows anybody to file with either DHHS or the police. The second point I'd like to make is simply this. I struggled, frankly, with understanding the defendant's argument concerning abrogation of the innocent agent doctrine. And usually when I struggle, I like to make analogies so that I can try to understand it better. And the best I could come up with is this. Let's say that you're born into a household.
If you could make sure you speak into the microphone, it just helps us. We sometimes can't hear you when you wander a little bit.
Boy, and I do wander, I apologize. Let's say that you're born into a household where your parents have decided that conversation needed to be polite. No coarse language, no swearing, no yelling or screaming. And then one day your dad comes home from work and he says, "You know, I've got another suggestion. We can't talk politics in the house." And what defendant, I think, would have you believe is that by coming in and saying we can't talk politics, somehow that abrogates the first rule, that all discussion has to be polite. And I just don't think that's accurate. I think defendant's position would be better if he were to say, yes, there's this polite doctrine that we have at our house, and yes, Dad came in and said we can't talk about politics, but then the next week the dad comes in and says, "You know what, I changed my mind. We can talk about politics. And by the way, let's forget about that courteous discussion rule. We can yell and scream all we want." Now, in that situation, things would be abrogated because that rule that Dad said we can't talk about politics, well, that's abrogated by the subsequent rule that you can talk about politics. And it also abrogates the courteous discussion rule, but that was done explicitly, which has to be the rule when you're abrogating the common law. So in that analogy, I don't think anything works with what the defense argument is here today. And I think Justice Markman nailed it when you said this common law innocent agent, it's a cross-cutting doctrine, much like the rule that you have polite discourse in your house.
What does "under this act" mean? What does that mean?
Yeah, I think it talks about the mechanism of how and where you file a report. The act obviously refers to the child protection law. And the word under, I think, can be said in accordance with. So any report that's filed in accordance with the child protection law. And again, under section 623, mandatory reporters have to report to DHHS. Under section 624, anybody is encouraged to file with either DHHS or the police. So I believe that the phrase under this act refers to any report that's filed by anybody with either the Department of Health and Human Services or with the police department.
So does it matter? Obviously, the child herself doesn't report to DHHS. It's the principal or the teacher. I can't remember exactly. But so are there really two innocent agents? And does that matter that we have? I mean, it's not just that mom asks innocent agent, assuming innocent agency applies. But I want, for the purposes of my trying to understand this language.
Sure.
It's that the mom has the child reported to another innocent agent who reports it under this act. Do the levels of innocent agents make a difference?
I think defense would have you believe that it does, but frankly, I don't think it matters how many innocent agents you have. Defense raised in their brief something about proximate cause. And I think his suggestion was that it would be too tenuous depending on how many innocent agents you have in the middle between the reporter or the person who instigates it and the Department of Health and Human Services. If you have more than two, more than three, well, it becomes too tenuous, therefore it breaks the proximate cause. And frankly, I don't think that's the case at all. As long as you have someone who makes or causes the report to be made, I don't think it matters how many innocent agents it filters through until it gets either to the Department of Health and Human Services or the police.
Even though it doesn't say causes to be made, it just says makes. That makes me think that that a certain number of innocent agents might strain the makes.
Well,
you know what I mean?
My first response is I think that's a factual question for the jury, right?
Okay.
They get to decide if that's too many, if it's reasonably foreseeable that happened. But second, again, the word makes is not defined in the statute. And so we go to the dictionary definition, which says makes or causes to be made. The U.S. Supreme Court in Giles did that. This court has done it in not Watkins, I'm sorry.
That other case.
That other, Hill.
Yeah.
Hill. You both went to the dictionary and found that the word make is defined as either makes or causes to be made. And I think that's relatively clear from this statute that that's how the word make here should be defined. So whether the defendant made the report herself to either DHHS or the police, or whether she caused that to be made through however many intermediaries, I think she still fits under that act.
But his opposing counsel indicates that causing to make language is in the broader statute and not the statute that's involved in this case. Isn't that correct? Isn't its absence somewhat pregnant in terms of interpreting the statute that's at issue in this case?
Well, could you ask that question again? I want to make sure I understand it.
Well, this is the argument made by opposing counsel that we've got two statutes here, and the later in time statute, 750.411A, contains the intentionally causes a false report statute, whereas the instant statute, 722.635, does not.
Got it.
Isn't the implication of that there's some relevance and purpose to its absence in the statute in this case?
And my response to that would be this, Judge. The Section 5 of the Child Protection Law was added in 1984 and 1985. Section 411A was amended to add that or cause to make language in 2004. So the defense is asking us to look back 19 years to a different legislature, under a different act, under a different statute, and try to make this in pere materia argument. And frankly, this court, the U.S. Supreme Court, has says that those issues are beside the point when trying to interpret what the original statute means.
So you're saying that the inferences we should draw from that intentionally causes a false report language would have been more substantial had that statute been the initial statute and the later statute not incorporated that same language?
Yes.
That gives rise to a different inference in your view than the inference in this case in which the sequence is reversed.
Yes.
And why is that again?
Because we're trying to infer the intent of Section 5 from something that happens 20 years in the future. Frankly, again, as I said, different legislature, different act, different purposes of the acts. And I just don't think the legislature really thought to themselves in 2004, hey, you know, when we amend this statute, we better go clean up every other section that we ever used the word make in, especially that one that we enacted almost 10 years ago in a different section of the law. I just don't think that is a sound argument when the language of the statute, Section 5, is really unambiguous.
So you think the critical language is implicit in the existing language, notwithstanding that the later legislature didn't think that way?
I do. And again, I bounce back to the dictionary definition of the word make. Make or causes to be made. And I think that's implicit in the language of Section 5.
Does MCL 750.411A apply to the facts of this case?
I think that our office could have charged the defendant under both sections, yes.
Penalties are the same?
Boy, I know this is a four-year. I'm not sure what Section 411A is.
It's a 4-year.
It's 4-year. Okay, so the penalties are the same.
In the future, you'll probably charge under 411A?
I wouldn't think so.
Why not?
Because the more specific statute here is Section 5. Let me throw this out too, and I don't know which way, well, I guess I do have an opinion as to which way it cuts, but defense brief seems to suggest that Section 5 under the Child Protection Law and Section 411A cover all of the same crimes, if you will, all the same acts. And I don't think that's true. I think Section 5 is a little broader than Section 411A. And I say that because, long-winded explanation for not very much of a point, but I'll make it anyways until you stop me. The child abuse laws, 750.136, they punish neglect if it causes harm. And I can envision a situation where parties are arguing in a custody battle. One of them wants a leg up, and so they want to allege something that the other parent did. And rather than saying, well, they've starved them, that's not going to go anywhere because the doctor will say, well, no, the child isn't starved. So rather than starving them, they just say, you know, the other parent doesn't feed them dinner on Wednesday night. Under the child abuse statute, I don't think that's a crime. If you look at Section 411A, it says the false report of a crime. So I'm not sure in that situation we could charge a defendant who just makes the false report. They don't give them dinner on Wednesday night. I don't think we could charge them under 411A. I think we would have to charge them under Section 5.
So if it doesn't rise to the level of a crime?
If all I did was made a false allegation that the other parent just doesn't give them dinner Wednesday night, I don't think that's a crime because the neglect, not giving dinner one night for a week, doesn't cause physical harm. And I think the statute 136 requires that.
Bit of a technical point, right? Your office is not busy charging every family law case where that allegation is made, are you?
I don't believe we are, no.
Right.
So can I ask you, what is your bottom line estimation or summation of what this court ought to do or say, if anything, concerning the innocent agent doctrine? Does it apply in every statute of the state of Michigan? Is there always an asterisk? And of course, makes in this statute or accomplishes some end or achieves some end in this statute always encompasses the idea that, by the way, if you you utilize an innocent agent to achieve these ends or to achieve this criminal conduct, that conduct is applicable to you as the principal or you as the defendant. What exactly ought, in your judgment, be the legacy of this case in terms of the existence, non-existence, partial existence, tentative existence of the innocent agent doctrine?
I think the doctrine of innocent agent applies to every criminal statute. And just as this court said, it applies, the common law applies until it's explicitly abrogated. Here, the enactment of the child protection laws did not specifically, explicitly abrogate the common law doctrine.
How would a legislative body, if it intended to, make it clear enough to you that the innocent agent doctrine were not to apply in that context? What would it say if it were inclined in that direction?
You know, in a footnote, I listed some sections where the legislature is very specific in that. One of the newer self-defense statute, it says, we hereby do not abrogate the common law in this regard up to this. The legislature could simply say, we hereby abrogate the common law. I mean, it's as simple as that. They could do it that way. Now, I haven't really, if the legislature enacts a statute, makes or causes to be made, that's kind of like the innocent agent doctrine. So whether I get it from the legislature or whether I get it from the common law, I think what's most important is that we get that. There's no way that the legislature could have intended to let someone like this defendant slip through the cracks, not only intending to file a false report, but then being cunning enough to use intermediaries to do it for him. And whether that's a legislative enactment saying makes or causes to be made, or whether we rely on the innocent agent theory, either way, the legislature could not have intended something different.
But couldn't you interpret that as the guiding, motivating force behind the amendment of 411A, what you just said?
I'm sorry, please ask me that again.
Your summation, couldn't we view that as the motivating force behind the amendment of section 411A? That they didn't want anyone who made the false allegation of a crime by using another person
Yes.
to slip through the cracks?
When the legislature amended 411A to include that intentionally causes language, I'm not convinced that they necessarily were aware of the doctrine of innocent agent.
Let me ask you this.
I'm sorry?
Let me ask you one last question, because now
Please.
we're both over time. If you lose today, does your office go back and bring charges under 411A?
That's probably something above my pay grade, but I would suggest that we do that, yeah.
Okay.
Thank you.
Thank you.
Your Honor, so I really only want to respond to one point that was made by Brother Counsel. Brother Counsel brought up this notion that under this act is somehow limited to reports made to DHHS or law enforcement. But that argument ignores a basic premise of the child protection law, and that's that police officers are mandatory reporters. So that distinction is illusory. It's not limiting in any way, shape, or form, because if I make a report of child abuse or neglect, they have a statutory obligation to immediately report that to DHHS. So the question becomes is, what does under this act actually mean? It cannot somehow be limiting, but then also cover every single possible situation that entails a report of child abuse or neglect. And the theory that's been advocated by the people in the Court of Appeals has been that it doesn't even matter who I make a report to. In this case, the allegation is that Ms. Mullins made a false report to her child, who made a false report to a teacher, who made a false report to a principal, who made a false report to DHHS. That's incredibly tenuous, and I think Chief Justice McCormick's questions on causation are equally applicable. And for the reasons stated here today, I'd ask the court to grant the application for leave to appeal and reverse and remand this matter.
Thank you, counsel.
Thank you.
Case will be submitted.